We're live.
All right. Hello, everyone. Friday morning, May 2nd. We're picking up some more work on S59. That is an act relating to the amendments to Vermont's open meeting law. And we have Representative Harrison here with us to talk about some language that he would like us to consider for inclusion to the bill. We had brought him in for an introduction in the past, so this is a second hit for you, buddy.
Thank you. Good morning. Jim Harrison, representative from Chittenden, and I'm here to talk about a potential amendment to the Senate bill that you're now looking at. As you remember, I talked to the committee earlier in the session with H 145, which had some suggested language around public meetings. And I understand that may be a little bit much to add and a little bit complicated to add all the language that were proposed. So I humbly come before you this morning and ask you to consider adding one line to the disorderly conduct section, which is 13 VSA 1026, which was included in H 145. And just for clarification, Mr. Chair, it's a different line than I talked to you in the hallway earlier this week about. So in consultation with not only Ledge Counsel, but a constituent that is involved in as a select board member and also as a municipal attorney, this other sentence would be more helpful. We have on the books, and I apologize for not bringing copies, but I'm sure Ledge Counsel can probably bring it up if you'd like to look at it. But we have a disorderly conduct section under 13 VSA 1026. And this adds a sentence, a subsection 6 to that section, which says substantially impairs the effective conduct of a meeting of a public body. And I'll give you a quick example. The other night.
Just read that one more time. I was just trying to jot it down.
On page 4.
Oh, it's on 4.
Yeah.
Number 6.
Sorry.
Substantially impairs the effective conduct of a meeting, public body. This is an additional clarification of what is meant by disorderly conduct. That section of the statute in current law says a person is guilty of disorderly conduct if the person with the intent to cause public inconvenience or annoyance or recklessly creates a risk thereof. And then it has a couple qualifying. This would add one more. The other night in one of the towns I represent, in many towns have similar individuals that they like to disrupt, talk over, etc. When they're at a meeting of the select board, school board, etc. And this individual started using profanity, from what I am understanding, loudly, and finally was asked to leave and escorted out, I believe, by the deputy sheriff. Supposedly, the deputy sheriff is not sure that they are able to bring charges because of not quite crossing the line potentially. But clearly, having an environment where someone is shouting profanities is not, I mean, I would say that's disruptive, but other people may disagree. That's why we have lawyers to sort all that out. So this, I think, additional sentence would help.
So just to that instance that you're describing, and maybe this is just sort of like unnecessarily splitting a question here. Was it relevant to like the conversation that the board was engaging in, or was the individual just like barking random entities from?
Don't know.
I don't know if that really matters. I was just kind of curious as to like what the ruckus was focused on.
Yeah, I don't know. I'm sorry. I could probably get a tape and review it. But I just became aware of that this morning. So,
Yeah, like I said, it was just
Yeah.
a description of said premise. So, and this is just like, I mean, as we've had conversations informally and a little bit here, this is a very regular ongoing occurrence.
and it's not unique to the town I represent. It happens. And you know, our municipal officials, select boards, school boards, planning commissions are in most cases essentially volunteers. And in this particular town, we've had several resignations. Why? You know, I'm doing this as public service, and if you're going to get sworn at and threatened and whatnot, why do it? And I know we've tried to address some things with, you know, some of our laws, but let's not make it more difficult than we can. And we think this sentence will help in a small way.
Okay.
So that's my ask. And I know you're continuing to look at things in the, you know, you know, it's not easy to navigate sometimes. But you have expert ledge counsel to help guide you, I think.
We are blessed with that. Yeah, no, I mean, I'm personally open to exploring this language and hearing from maybe possibly the sheriff or a deputy sheriff,
Sure.
you know, just to get a little bit more lived experience and perspective on that.
Yeah.
So I appreciate.
Okay.
you.
No, I can certainly reach out.
Yeah, if you could,
Yeah.
you know, maybe ask him to email our committee assistant. We'll
Sure.
speak with
Great.
council about the nuance of the language, but I think
Okay.
this is certainly worthy of some more.
Work on that.
discussion, especially once we have some more body mass here. We're a little light on numbers today. Any other questions for Rep. Harrison while he's with us?
I have a question directly for him, the budget council.
Okay.
So if we.
So Tucker will come up in a second.
Okay.
If you don't have anything left for Mr. Harrison, we can just shift over to Tucker.
Sense.
Great.
Thank you very much.
Thank you very much, sir.
Have a good weekend.
You do.
Sorry, I'm spilling on the table. I'm sorry.
I don't sit there.
Can't help it. Like that may have been intentional, but no.
You're not here to talk about your performance in March Madness, right?
I would like to avoid that on the record. Good morning, Tucker Anderson, Legislative Council. Representative Harrison introduced that sentence from H 145 as introduced. I am
Other side.
happy to
We are on video.
listen. It's been a long week.
No, I got you back, brother.
I think it looked okay.
Had like a big Ernie McCracken from like Hayden Penn thing.
Oh, nice. Well, I age. Let's see. So you got an introduction to that one sentence being added to the disorderly conduct statute. Depending on how the committee wants to proceed with the time that you have, I can give you some background, discuss the scope of the disorderly conduct statute and how it relates to these meetings currently in the law, and describe generally the steps that H 145 as a whole goes through, and then what that one sentence does legally. And if that sounds like a good plan, can do that. But first, I wanted to make sure I got to any questions that had come up, so I didn't know if Representative Pincinel had.
Yeah, let's go with Rep. Hisnell's question. I think that
Okay.
run through would be very, very.
Yeah, I just know that this happens a lot. I wouldn't say every town, but I think, I would almost guess that most towns have experienced this in one way or another. There's always that disgruntled person. So I think it would be great to add something in the open meeting law for that. And then my question was, if we do that, does then it go to judiciary? Because would we want some sort of authority to remove them? I mean, I'm just asking, does it then trigger judiciary because we're talking about fines and penalties of. So that was my question.
So I'll note that that sort of commitment question about where bills go after an initial policy committee is more a question for the parliamentarians. But in my experience, whenever you have an adjustment to the scope of a crime that has an associated criminal penalty, typically the judiciary committees will take at least a drive-by look at how that crime or its associated penalties are being affected by the bill. So there's always the possibility that even if it isn't committed to judiciary, that they may want an opportunity to take a look at the language and provide input. There's actually quite a bit of interesting background to this area of the law and to the situation that Representative Harrison teed up. If you have H-145 up in front of you, take a look at section 3 of the bill. Section 3, which is on page 3, line 17. It's a disorderly conduct statute, 13 VSA, section 1026. It states that a person is guilty of disorderly conduct if that person, with the intent to cause public inconvenience or annoyance, or recklessly creates a risk of public inconvenience or annoyance. And then if we move down to the existing subdivision 4, without lawful authority, disturbs any lawful assembly or meeting of persons. So that is the foothold that currently a public body would use in the event that an individual's conduct rises to the level of disorderly conduct. However, there was a case, State v. Colby, that was appealed all the way to the Supreme Court of Vermont. It dealt with a disturbance at an assembly at an academy. If my memory serves me correctly, it was St. Johnsbury, where there was a federal official who was giving a commencement speech. And one of the parents who had planned to do a protest stood and started yelling at the person, calling the person names, and disrupted the ceremony, and was given a warning that that person had to stop screaming, was escorted out of the ceremony, and nothing further happened. So got a citation for disrupting that meeting under that subdivision 4. Supreme Court of Vermont said that that level of conduct was not high enough to be charged with the crime. Even though the ceremony stopped for a brief duration, and even though there was no dispute as to whether there was a disruption of the meeting or lawful assembly, in fact, there was a tension between that individual's First Amendment rights, the rights of that group of people to lawfully assemble, which is another First Amendment right, and then the appropriate notice about the disruption and the opportunity to stop and leave, which the individual did, told to stop and left the assembly. So the Supreme Court of Vermont, looking at cases in other jurisdictions, and in particular a set of cases from the Ninth Circuit, determined that there's specific threshold requirements that an individual's conduct has to meet in order to be cited under this section of law. Otherwise, it would be a violation of that individual's First Amendment rights. The specific language that was used in State v. Colby included that the individual's conduct would have to substantially impair the effective conduct of the meeting or cause the meeting to stop for a significant duration. So the language that Representative Harrison's bill adds to this Title 13 section governing disorderly conduct is specific to meetings of public bodies, which I'll get to the legal reasoning there in a second, and uses the exact language from the State v. Colby decision, stating that an individual can be cited for disorderly conduct when their intentional or reckless conduct causes substantial impairment of the effective conduct of a meeting of a public body. So it uses that language from State v. Colby, clearly articulates the standard that would be analyzed here. Remember that the individual can stop what they're doing and leave the meeting out of their own volition and likely would not be cited. Now, the reason that this isn't an amendment to subdivision 4 as it stands right now and is separated out as its own subdivision is that there is an even higher standard potentially when you're talking about the meeting of a public body instead of just a lawful assembly of a group of private individuals, for example, at the academy. And the reason for that is that for you all, the First Amendment, you are expected to endure a certain amount of heckling. The courts in the Ninth Circuit have in fact stated that that sort of heckling, shouting, even name calling and mildly disruptive behavior is to be tolerated and accepted by governmental bodies because it is part of the democratic process. So this is separating out meetings of public bodies, articulating the standard that we have been given by the Supreme Court of Vermont, and teeing up potential violations if they meet this standard that is applicable to meetings of a public body. If you were to look at H-145, there's a series of steps that it goes through. It has an expression of legislative intent that is quite long. The reason it is long is that it cherry picks guidance from the Ninth Circuit, a few other circuits that have taken a look at this issue, and the State v. Colby decision in order to tee up one, that public bodies and governmental bodies in general are supposed to expect that they are meeting a confrontational audience every time they gather, right? It's not all whipped cream and fun. Sometimes there's rusty nails and shouting. So,
Don't forget the broken glass.
but also that individual's right to speak is also corralled and in tension with the right of other people who are attending the meeting to assemble peacefully. That is another First Amendment right. And disrupting those other citizens' ability to attend a public meeting or a meeting of a public body and participate peacefully in it is a disruption of their rights. So all of this is articulated in that legislative intent. You are giving guidance both to the public bodies and to the state at large. Here are the factors that are in play. Here's what you have to expect. This is what the General Assembly wants to see from behavior out of all of the parties involved and the considerations that go into removing someone from an open meeting and potentially charging them with a crime. The second step that it takes is to amend the open meeting law to make it expressly clear that a public body has the authority to adopt rules governing the removal of an individual from an open meeting. It is presumed to be part of existing authority in 1 VSA 312 subsection H, the current law. It states that the public shall be given an opportunity, a reasonable opportunity, to express its opinion on matters considered by the public body during the meeting, provided that order is maintained. So that proviso is important. They're allowed to maintain order. And it currently states that public comment will be subject to reasonable rules established by the chairperson. It adds on to that authority, new authority for the public body as a whole, not just the chairperson, to adopt rules governing the removal of an individual from an open meeting. It made that distinction in order to ensure that there would be adequate notice to the public that there is the possibility that you could be removed from a meeting for violating these specific rules governing the conduct of members of the public. Why was that important? Because the primary step here is providing sufficient notice to the members of the public attending an open meeting of what conduct could lead to removal and therefore potentially down the line a criminal charge. The final step was the disorderly conduct update. Representative Harrison is 100% correct that you could add the disorderly conduct provision and you don't have to include any of the updates to the open meeting law. And all that eliminating those first two things would do, it would get rid of some of the guidance provided to the public bodies in the statement of legislative intent. It would remove some of the guidance to the courts who might be interpreting appeals of violations in the future. And it would leave the discretion for adopting rules governing conduct of the public and removal of members of the public to the chairperson, which is what is currently in the open meeting law. So that's the whole of it. The State v. Colby decision is very interesting. The Ninth Circuit cases that it cites are awesome in their explanation of the tension between the right to lawfully assemble and the speech rights of an individual who's attending an assembly of a public body. And I'd be happy to send them to you because there are some fantastic quotes in there, particularly about how public servants should expect confrontation from members of the public. Yeah.
Please feel free to share. I enjoy a light read. Rebecca, did I see a hand?
Yes, you did. What was the defendant's name again?
In the Supreme Court case, Colby.
I also have a question, clarification. So what Representative Harrison is asking for already exists? That the chairperson of a public body, public legislative body, has the right to maintain control in whatever way, shape, or form they can determine at that moment to do.
Yes and no. Yes, the open meeting law allows the chairperson of a public body to adopt reasonable rules governing public comment at a meeting, not public conduct throughout the entire meeting. And even if those rules are adopted, it is the enforcement piece that is really in question. What level of conduct meets the Supreme Court's explanation of how subdivision 4 of 13 VSA 1026 subsection A can be applied? What is the scope? At what point does an individual's conduct cross the threshold where they can be charged under that section? And without this level of specificity, community members who are charged with enforcing the law here maybe don't feel comfortable citing an individual. There was a very recent case involving the city of Montpelier where an individual was removed for disorderly conduct at a city council meeting. And that case was thrown out fairly quickly when it was challenged. And that is because some of the ambiguity surrounding how this may be enforced in the context of a meeting of a public body.
I find this really frustrating, as I do many things, because I could put myself in the seat of chair of the school board. And we have some really angry constituents who come to the meeting and continually stand up and raise their voices over what is being said during the public meeting. And without the authority, without the express authority to have them removed, I could ask them to leave and they wouldn't leave and they would continue to disrupt the meeting. So I would find it extremely frustrating and in some cases a little bit scary that I would have to adjourn the meeting without business being conducted and then walk myself out to my car in the parking lot. with these angry folks following me. So I understand where Rep. Harrison is coming from, by asking for this, and I just don't know where to go. To find a reasonable solution for this, but, as others have said, we have so many volunteers who are doing these jobs and putting hours and hours of time in. You know, when you take a position like that, they're like, oh, no, it's no time at all, once a month. Well, there are a lot of hours behind the scenes to doing these types of jobs in your community. And we are having a tremendously difficult time enticing young people to join these organizations, do these jobs. And those of us who are doing them are getting older and maybe wish to retire from them. So I see that this is going to become an even greater problem in the future. And we all agree that civil discourse has kind of gone down the tubes recently. It's not really a thing anymore, which is quite sad. But people are more and more willing to put themselves out there, to be very vocal and sometimes in a very hurtful manner. So I am very concerned for our small town volunteers on this, or people who are paid a nominal stipend to do this work. I don't know where to go.
Rep. Honors Evans?
Yeah, I just keep thinking about what Tucker said about how part of the job is accepting that, what did you say, a certain amount of heckling is
Part and parcel of democracy.
yes, it's part of the gig. And I think, I mean, yes, I understand your concerns completely and share them as well. It's just that despite the fact that, you know, there's not a lot of financial gain from most of these positions. People know what they're signing up for to a certain extent, but that doesn't necessarily mean that you get harassed, right? Like there's that line between free speech and then harassment. I guess a question for Tucker is, are there other sections of law, like not this open meeting law part or whatever, but are there other, let's say it's not a public meeting. Let's say I'm in the grocery store and someone just starts yelling at me. Are there, you know what I'm saying? Just like a regular person, are there other things in statute that would say, you can't do that? You can't shout at me and be like, don't buy that brand of milk, buy a different one. Like,
Yes, but there's a whole array of where that sort of conduct could fall within, you know, a particular criminal provision, ranging all the way from simple assault to harassment to, if it goes on for long enough, stalking. It could also just be this same section of law, but it's, you know, intentional behavior that is causing a public disturbance, you know, in the grocery store. It rises to a sufficient level that it becomes criminal conduct.
would that apply in these situations or not so much because it's a public meeting? And so that gives a little more leeway.
The threshold is higher during the public meeting.
Yeah.
And that, you know, that whole intent section is teeing up and trying to give guidance around, you have multiple interests at these meetings that the public body is trying to balance. They're trying to conduct their business in an efficient way. They are trying to balance the input that they are receiving from community members. You have an individual member of the community who is disturbing the assembly at large, including the conduct of the business of the public body. But that individual is also potentially stifling First Amendment rights held by the other members of the public by speaking over them, interrupting them. And really the guidance that we have is the conduct has to at least cause the meeting to stop. And not only pause, but like you stop the meeting for a significant amount of time because the behavior is causing the meeting to not be effective, that the business can't even be conducted because of this individual's behavior.
Because they're exercising their First Amendment right is also prohibiting other people from
Assembling peacefully or using their own speech rights to participate in the public comment period, for example, or even just for them to participate in the public body's meeting at large. You know, there are individuals who will be at these meetings that want the public body to be able to conduct its business. They have a vested interest in the meeting happening, in the business taking place.
No, and I mean, I have scenarios running through my head right now that go beyond the scenario that Rep. Harrison was describing here, where I've seen instances like this completely halt for an extended duration of time the action of the public body in a manner that was aggressive and, yeah, impeding the duty. So, all right, what do we want to do here, team? You want to talk about this a little bit more? Do a little bit more research on it?
Yeah,
Definitely.
Okay.
yeah.
And thank you for that excursion through statute, sure. All right. We got our other guests here for the other components of the conversation. We'll start off with Lisa Loomis. We had seemed the committee members had some follow-up questions based on the original testimony. So we wanted to just have her back. Hi, Lisa, how are you?
I'm good. How are you?
Good. Yeah, no, as we just mined into this deeper, some more questions and clarifications had popped up with some members, so we appreciate you coming back in. With that, to the committee members for a little bit more of the clarification in and around the piece that we were discussing.
I can start with that.
Please.
I believe the clarification we needed is about information relating to interest rates for publicly financed loans. That was a little unclear to me. I have a bunch of notes on it, but if you could reiterate what exactly you're asking for in which circumstances, I would really appreciate.
Sure. And I also have with me our executive director, Mike Donahue, who I will also ask to weigh in once I'm done answering your questions. Well, I think it's quite clear that all interest paid on any public loans is my money or your money or our money. So we have a right to know interest rates. We need to be able to watch you make the sausage of negotiating interest rates. And we also need the public oversight to be able to ensure that if I'm a select board member negotiating a loan for a new road grader, that I'm not using my sister's bank or my best friend's finance agency. And I would also add, which as I think I said earlier, that if, for example, in my town, Waitsfield's in the middle of working on a municipal wastewater project and is cobbling together a $15 million finance package, and that package includes loans and grants, and a specific portion of that is going to be federal loans from the USDA, which are at a fixed and published interest rate, and a certain portion of that's going to be state funds, possibly at a fixed and published interest rate. So interest rates are as public as the term of a loan or as public as what the loan's being used for. I can't really fathom why they would not be public. Unlike the price of a real estate purchase, if my town is negotiating to buy a chunk of land, that strikes me as a very different beast than the finance rate with which that land will be purchased or financed.
Thank you for that. So you're really concerned about the public body as a borrower. Is that correct?
Yes. Any
Okay.
public body, any entity, anybody who's going to pay back a loan with my money or your money.
Thank you.
Mike, do you want to add anything to that? Or did you have further questions for me?
I do know.
No, I think it's an appropriate time for Mr. Donahue.
Mr. Chair, thank you very much for taking the time, and the rest of the committee. Yeah, I think the last time we were here, Lisa was flying, and John Flowers and I did our best to impersonate Lisa and try to expand on what her letter said. If I remember correctly, this provision was put in the Senate and it wasn't quite clear. I don't think 100% clear from this committee why it was put in. And I thought somebody was going to look back and try to figure out why it was and get back to us or something. And I may have misunderstood, but I did not realize that this was still sort of out there again. But I think, like Lisa said, you know, it's sort of like the interest rates are out there. When you have bid openings, the envelopes get slit open. The paperwork says what the percentage rate is or the interest rate is going to be, whether it's whatever CDs or whatever at a bank. You can do a comparison and the taxpayers can see what the town is paying or getting for its CDs at each of the banks and everything like that. And I guess I'm still not sure why they think that kind of interest rates should not be known to the general public.
I don't believe that we found out why the Senate included that, but perhaps our ledge counsel could speak to that.
Please, sir.
Thank you.
Good morning again, Tucker Anderson, Legislative Counsel. So want to provide clarity again on this. I think we've visited this twice. I gave you a chart where I provided some context. I think there's some misreading and misunderstanding of the language, the express language that is used in this subdivision. This is not applicable to public borrowing or public indebtedness. This is where the governmental corporation is the creditor, acting like the bank. And publicly financed loans are publicly guaranteed loans like student loans or certain types of housing loans. And I can't speak to the policy choices that were made or why they were formulated, but I gave you a corollary, which is that even within the context of the Public Records Act, where public agencies are receiving information about certain financial instruments from banks, there is an applicable exemption that protects that sort of confidential business information. So you're talking about an instance where a public body is negotiating and considering the interest rate that the public body is going to offer for a loan to whatever purpose. Publicly financed loan, not publicly financed indebtedness.
Is there, may I ask a clarifying question about that?
Certainly.
So can we make this concrete? My town builds 10 houses and is going to sell them to at affordable prices to 10 qualified people. Is it the interest rate that the town is then going to offer somebody buying one of those homes that is being negotiated behind closed doors? Assuming the town has the capital, I'm guessing this is town money, right? As I understood what you said.
The fact pattern you presented may be more complicated than we need to get into.
Okay.
But if in your situation, and I'm trying to look into the camera so I can make eye contact with you, even though you're behind me.
Good redirect. Yeah.
In your situation, if the transaction involves the town offering credit money with an attached interest rate for repayment from the private individual, then the discussion of the interest rate that would be attached to that loan could fall under this. And an important thing to note is that perhaps the public body that is involved doesn't care about having public discussion and never moves to enter executive session. But if this remains in S59 and is added to the open meeting law, it would give that public body the opportunity to protect potentially confidential information about the interest rate it is going to offer for that purpose.
But-
And the examples that I gave are perhaps the most common you could think of and probably relate more to state agencies than municipal corporations. And there are state agencies that have been created by statute that, part of their duty and charge from the state is to offer loans that are publicly financed for specific purposes.
And then just to follow up on that. So if, let's make it a state agency, is offering money to purchase, and I'll use homes because it's simple, and the state agency is going to offer 4% interest rates if your income is above or below $100,000 and 3% interest rates if your income is above or below $50,000. These are just hypothetical numbers. I'm trying to understand at what point would we be able to know that my town or my state has a pile of money of $5 million that'll be loaned to people to buy housing. At what point will we be able to know that this $5 million is earning 4% and 3%? Is that not legitimate public information? Not necessarily that Bill Smith is getting a 3% interest rate, but that interest rates vary from 3 to 5 and will yield an annual, provide an annual yield of X number of dollars.
Sure. So that information is going to be public at some point, and these executive session provisions, with one very narrow exception, don't cover action taken. It covers the deliberation on these subjects. So at the time the public body makes the decision to set the interest rate, that information would certainly become public. And again, I can't offer any testimony about why this is here or what the policy reasoning is behind it. I can only offer that it is not uncommon for the consideration of where to set these rates and the financial information around why a certain rate may be beneficial over another would, in many contexts, be confidential anyway. And something to kind of remember is that, let's say there's confidential business information that any public body under current law is going to consider. If that is given to the public body in the form of a public record and it contains that confidential business information, under current law, a public body can go into executive session to consider that information anyway.
And so we don't know where this provision came from or why?
I was just going to.
Oh, thank you.
Tucker can't, say why they made the policy choice. My understanding was that it was specifically related to a situation with a state agency and this situation with the financial information being confidential and not wanting to have to disclose like that, or not wanting to have to publicly discuss whatever the process was to arrive at those interest rates. I think that's what it was, right? It was from a state agency. So my question would be, is there a way, if we were really specifically, if this, I believe it arose from like a couple very specific situations. So I'm wondering if we could make the language more specific to simply only cover those situations and not have even present the opportunity for it to apply to a municipality as opposed to it.
That would be clarifying. That would be clarifying because what you're describing feels like what you might be akin to spot zoning, right? Like you're creating a loophole in the entire state's open meeting law for one state agency. Perhaps there's a better way.
Yeah, I think. Yeah, I'm wondering if it's already confidential information, the financial information, it's already covered in executive session, then A, I guess, why do we need this in here? And then B, can we make it? Well, I guess we don't want to say all state agencies, like, help.
I am happy to help. I remember covering this in one of my walkthroughs and discussion, but
Yes.
sometimes I forget that my feet move so fast through these issues that I burn up turf and don't always make sure that everyone's with me. The exemption that relates to confidential business information
Mhm.
has a test built into it. So if the discussion of a public body involves a record that is confidential in the Public Records Act, you can go into executive session just to discuss the matters within the confines of that Public Records Act exemption, right? So under current law, that box for confidential business information includes trade secrets, meaning confidential business records or information, including formulae, plans, patterns, processes, tools, mechanisms, compounds, procedures, production data, compilations of information that is not patented, which a commercial concern makes efforts that are reasonable under the circumstances to keep secret. There's the test. There's an advantage that the public agency or the person who is submitting information to the public agency has over another marketplace competitor, right? And there is a concern, a commercial concern that requires reasonable effort to keep that information private. So you have a test that is applied that the public body, likely the legal counsel advising the public body going into executive session, says, this is confidential. It meets the test. This language doesn't require that test. It allows for the deliberations around this. You mentioned possibly clarifying or narrowing. It is narrowed down to the specific matter at hand, the interest rates. And again, specific to when the public agency is the creditor. But it would not require that sort of analysis around whether or not this is a confidential business record. It would allow the public body to, on a motion, enter executive session to discuss information related to the interest rates.
Okay, so the problem isn't the language, it's our understanding of it, or my understanding of it.
If you want to make the language very specific, can certainly do that. So it's information related to the interest rates, written that way to cover the background information and discussion around the interest rates that will be public at the time that they choose them.
Once it's decided on and then forward is an action.
But you could make it more narrow. You could tie it specifically to state agencies if that's the will of your committee.
Mr. Donahue, did I see you with a hand a few moments ago?
Yes, thank you. Maybe because it's Friday and I'm running out of gas here for this week, but I'm having trouble grasping this thing. And I guess I'm wondering why the people who have proposed this have yet to show for testimony here on your side of the house. I guess I'd love to hear from them firsthand. Tucker does a great job, I think, boiling things down. But if somebody's so excited about some provision to add to the bill, it would seem that the people pushing it should be here so you as lawmakers could hear that. That's just my thought, that you might invite them in and have a better understanding and answer some questions, or have them answer questions.
Thank you for the suggestion, Mr. Donahue. Since this bill is an S bill, it came to us from the Senate like this, and it's up to us to accept it or ask questions on it or reject sections of the bill. So we, until recently, did not have an objection to it. And then looking deeper into it, I wanted clarification as to what the objection was. So that's why we invited you folks in this morning. Certainly, whomever added this or asked for it in the bill in the Senate, I do not know who that is. And I would suggest maybe speaking to your senator about it, if that's an appropriate thing that you want to approach them about, because It came over, passed to us on a majority vote from the Senate.
But you have the right to strike that if
We
you pass
do.
this
We
along.
do.
And you can
Certainly.
investigate it. I assume you can investigate it and ask whoever spoke in the Senate to come in and make the same pitch to you people. I mean, that's the way I've understood it in the past, that that's how bills are passed, but
Yeah,
maybe.
so we can certainly strike it if that's our will. So I guess we can have somebody try to figure out who in the Senate asked for it.
Yeah.
But I'm not personally having an objection to it now that it's been clarified to me. So that will be up to another member of the committee to look into.
I have a question.
Hi.
Sorry, I'm trying to raise my hand, but I can't find the camera.
Sure,
That's okay.
go ahead.
Is it really necessary then, if it's already, as Tucker explained, it's already in a protected box? It's already like carved out in a special little niche where it's safe to be discussed. Is that provision even necessary?
That's what we're trying to suss out. So I would like to note that we actually have Chris D'Elia from the Bankers Association here, and I know he's not on our witness list. But I didn't know if he would want to offer some insight on this.
On this particular issue, I can't offer any insight into that issue, just to bring to your attention, but.
Not on this particular one. Okay, wasn't sure because of the interest rates and some of that stuff, if that was like floating into your orbit at all. So what we're gonna do here is we are going to chat a little bit more with the colleagues in the Senate on the origin of the language. We're still doing scheduled work on our agenda with this, so we're not marking up and voting. Because we have a lot of different moving parts within this bill. So, does anyone have any further questions for our guests? Yeah, I was just wrapping. Anything else for Lisa and Mike? Okay, well, thank you very much. And we are definitely going to do some more back-end research on this provision.
Thank you very much for the opportunity.
Gotcha.
Thanks for taking the time. Appreciate your work. Thank you.
Of course, thank you. Bye-bye. And yes, while we have you here, sir.
Good morning. For the record, Chris D'Elia, President, Vermont Bankers Association. Appreciate the opportunity to come in and not talk about that particular subject, but something else that I promised Representative Kornheiser I would bring to your attention. If you may recall, last year, you folks in this committee and up in Ways and Means had a discussion about municipal tax sales. And you created a working group to go off during the summer and fall and have conversations about some issues that were highlighted in the statute and come back to you with recommendations. And that process occurred. But one of the challenges that we explained to Representative Kornheiser, and again, she asked me to bring it to your attention, was this notion of a working group that is not supported by legislative council or supported by an agency still falls under the public meeting statutes. And I'm not here to say that's right or wrong. My commitment to Rep. Kornheiser was to say that if you look at those in the future in statute, you would ask as part of the working group that you provide some level of support, either through an agency or ledge council. We had lay people around the table who had no notion of public meeting statutes whatsoever. And we spent a meeting and a half with the Secretary of State's office and asking legal counsel here, who was kind enough to do so at the request of Kornheiser, to help us understand what our obligations were. We didn't object to the obligations, but it threw a wet blanket on the ability to get our work done in a timely fashion. Because now you had folks who had the responsibility of posting agendas, recording the meetings, posting the recordings. We ended up doing that through the state library system. So long story short is it's not an issue of us being in favor of 59 or against 59, but it is an issue of how the legislature creates a working group that is not supported by an agency or legislative council. I don't know if it needs statutory changes, but this bill presents an opportunity at least to bring the issue to your attention.
Thank you. That's really interesting, but I can see how that happens when you have folks who don't do this for a living.
We even had some lawyers at the table as part of the group who were very concerned that we didn't do anything that would have run afoul of the public meeting statutes, which I don't believe we did, but.
I was going to point out that municipalities have Vermont League of Cities and Towns to provide guidance for open meeting laws. And it sounds like it doesn't. Certain boards don't have access to that because they're not municipalities. So.
Well, we did, VLCT was part of the working group.
Oh, okay.
And they did provide some thoughts. But again, you're still left with a group of lay people who are trying to get their arms around what the LCT offered, what Legislative Council offered, and what the Secretary of State offered. We just want to make sure it gets done correctly.
Thank you.
Rep. Ismail?
Just, could you spell your last name?
Sure, D'(ELIA), represent the Vermont Bankers Association. My apologies.
No, that's fine. I wrote
For
it down.
that.
Casual banter.
For the record.
Yes, for the record. Thank you, sir.
And that'll be posted on our webpage very shortly.
Yeah. Okay, noted as something to look at as because we're still having conversations in and around a bucket of these scenarios.
And I don't know whether there's like governing guidelines that committees work within, that maybe this gets embedded in guidelines or something that helps to create understanding amongst the committees. When you create working groups, it probably doesn't need to be statutory. But again, this offered the opportunity for a conversation.
No, I appreciate you at least like putting the words out in the open for us. Any questions for Chris?
Great. Thank you very much for your time.
All right. Perhaps the witness list. So, I mean, we're well aware this is the one bill that we're sitting on right now that is definitely requiring the most work and attention. So that's not a new thought for the table. We'll wrap committee work up for now on this. I don't want to have any real discussions on anything with light body mass.
Yeah.
So, Autumn, take us off, and we'll noodle on some of these perspectives over the weekend and discuss more further next week. And enjoy your lunch, folks.